Hello and welcome everyone to another episode of The Agenda. Today we will be taking forward our discussions about technology and its overlap with the legal framework, specifically in India. Our discussion today focuses on smart contracts, the technology behind them, their application, and certainly how the legal regime needs to adapt the functioning of a smart contract and what effectively is the law on smart contracts. At the same time, we will be discussing the law in India related to gaming, which will include fantasy sports, the law as it has been developing on games of chance and games of skill. We'll be discussing the case law regarding that, the exceptions that have been made across states and the high courts that have commented upon the same. And then we'll be certainly discussing the emerging trends in that field, the law regarding gaming, gambling, sports betting, and wagering contracts. Right. To discuss these two areas and the overlap of these areas, we have with us today an esteemed panel of two advocates. Please welcome me. Please join me in welcoming. Pardon me. Please join me in welcoming partners, senior partners at TKC Partners. We have with us Mr. Zafar Khurshid.
Hi Ajay, thanks for having me.
Welcome, Zafar. And we have with us Mr. Sameer Talwar.
Good evening all, thank you for having me here.
So Mr. Zafar Khurshid has completed his LLB from the Faculty of Law, Delhi University, and post that has completed his training, advanced training in law from Queen's Mary and Oxford University. Mr. Talwar has completed his LLB from Nalsa, and post that has worked both in the corporate sector as well as litigation, where he's worked with AZB partners and ALA associates. Presently, both of them are partners at TKC Partners. A very warm welcome to both of you, Zafar and
Thank you.
So our discussion today will focus on two parts. We'll begin with the law pertaining to gaming and gambling, betting, wagering, as we must have this clarification set up properly. And I would welcome Zafar to make the first comments regarding this, regarding a very basic introduction to what is the status of wagering contracts and what is the status of games of chance versus games of skill, and how is the law developed in India pertaining to this?
Yeah, thanks Ajay. Very happy to speak on this very interesting topic, and I really hope some interesting discussions are going to come out of it. So just to start, the sort of background of gaming law in India. Let's start by making a distinction that these terms may not mean the same things in common parlance that they do in legal parlance. I think if I talk to anyone on the street about gaming, you could talk about Fortnite and you can talk about PUBG, but that's not necessarily what we're talking about. There will be interactions as we discuss some cases, but that's not necessarily what we're talking about. Gaming here is a very wide word that involves betting, gambling, wagering, and then the general law that regulates gaming and its interaction basically with these three concepts, with these three acts. So the sort of precursor of Indian law is the Public Gaming Act of 1867, which was adopted basically on the basis of the British Gaming Act of 1845 and the Betting Act of 1853. So this was the foundational law. After this, of course, the Constitution of India, when it was founded, it gave all matters pertaining to betting and gambling were introduced in Entry 34 of List 2, which means they come under the domain of the state legislatures. So there is not actually a union act on this. Having said that 14 states and union territories did adopt the Public Gaming Act of 1867 as is. So that became the law that continued as the law in a big part of India. But a lot of states passed their own laws under, as I aforementioned, Entry 34. And so there is a great diversity in terms of what the law recognizes or prohibits across India. And that's something that we'll go into more in depth as we continue this discussion. But that's the background. That's the background of the law. Now, I actually, when I spoke to a few colleagues when I told them I was going to talk about this topic, and their first sort of question was, and I'm saying colleagues as people who have a basic foundational understanding of law, certainly in India, and the reaction was, "Oh, does India have a gaming law?" And because I think the general understanding is that betting is illegal in India. Diwali ke time pe sab teen patti khelte hain, but other than that, betting is per se illegal in India, and that's not very far from what the truth is. There is a general prohibition on wagering and betting, but there are key exceptions, not just in the general law under the states that have adopted the Public Gaming Act, but in certain states, there are great exceptions to this general rule.
Okay. So could you elaborate a bit on that as to what are the
Absolutely.
specific...
So I think you can read, there are great extremes in this. On the one hand, you have states like Telangana that have completely prohibited I should disclaim, not necessarily by legislative enactment, but by executive action. They have completely prohibited games, even of skill, games of skill or of chance, whether online or offline, for money. There is a complete prohibition. That's on the one extreme. On the other hand, you have, many would be familiar with Goa and the fact that Goa has casinos. So Goa allows certain electronic gaming and gambling via gaming parlors onshore, as well as certain other games are allowed on offshore casinos. Of course, this is all through a license. You have to obtain a license from the state to run whatever is a permissible activity. There are even more expansive states like Sikkim. Sikkim, in fact, allows online betting on sports, esports, all kinds of games, not just a skill. They specifically say even wagering on games of chance is permissible, but it's only permissible in specific gaming parlors online through an intranet service, which means you cannot access this from other states in India. Nagaland has an extremely expansive definition of games of skill. So, sorry, let me just backtrack a little bit. The general prohibition to wagering and betting. The states, many state laws recognize that this shall not apply to games of mere skill. That's the generally preponderant phrase, is games of mere skill. The idea here is that if what we're regulating is wagering, is betting, actually what we're regulating is gambling. And why are we regulating gambling? Because it's basically the idea, we don't like the idea of somebody getting money for nothing. All right. So games of skill are accepted because this is a legislative recognition, a judicial recognition, that where someone is putting in effort, where it requires skill and it requires work and it requires the application of mind and effort, well, then this is not necessarily gambling. This could be akin to a profession or a trade, which is protected under 19(1)(g), under the Constitution under 19(1)(g). So it's the freedom to carry on a profession, and it's outside the realm of mere chance. So Nagaland has a very expansive definition of games of skill. In fact, their act specifically recognizes not games of just mere skill, but games where there is a preponderance of skill, even if there is an element of chance. So they recognize it. Of course, there's a Supreme Court judgment, which is K.R. Lakshmanan versus State of Tamil Nadu, which specifically recognizes that horse racing is a game of skill. So placing bets on horse racing is permissible. It is legal. So any state in the country which has an exception for game of mere skill, now it is legal to place a bet on a horse race. Why? Because the court says there's an element of skill involved in it's if you have two horses of a similar pedigree, there are many elements, and the person who's placing the bet has to know what is the pedigree of the horse, what are the weather conditions that day, what is the performance of the jockey, what's the weight of the jockey, has the jockey lost weight, what's his personal life like. These are all things that are going to inform your decision, because the exact same horse can perform differently depending on the jockey that's riding him. So the court has recognized that these are elements of skill. This is not just mere chance. This is not somebody who's putting down money and there's a 50-50 shot that he'll win or he'll lose. There's a game. This is a complete skill involved in betting on horses. So KR Lakshman versus State of Tamil Nadu recognizes that horse racing is a game of skill. So now any state that has an exception for mere skill, I mean, again, places like Karnataka, Tamil Nadu, West Bengal, all of these states, their acts recognize game of mere skill as an exception. So that's not to say that they don't recognize that this is wagering. It's not to say that they don't recognize that this is betting, but they recognize that the outcome of the bet is not just it does not depend on a pure preponderance of luck. So that's why these fall outside the general prohibition on gambling and wagering in India. And so Nagaland, I have to come back to Nagaland. It has a very expansive definition, and in fact, it's one of the few states that defines wagering and gambling in its act, and also specifically publishes a list of activities in Schedule A appended to the Act, which is an extremely expansive list. If I may read out a few items to you, it recognizes wagering on all of these activities: chess, Sudoku, quizzes, bridge, poker, rummy, spades, solitaire, virtual golf, and very key point, it recognizes wagering on virtual sports, virtual sports fantasy league games, virtual team selection games, virtual mystery and detective games. Now, this is a key distinction because, again, what I pointed out earlier was there's a great discrepancy, great diversity in the law across the country. Because even some states that recognize that wagering on a game of skill is not a prohibited activity, they feel that when the same game of skill shifts to the online, the element of luck seems to change. Why? Because they feel there's scope for interference. So in the case of Messrs. Gaussian Networks Private Limited versus Monica Lakhanpal and the state of NCT, the plaintiff he filed a petition under Order 36 Rule 1 to seek the opinion of the court on whether playing skill-based games for money online on the virtual space would render that activity illegal or prohibited. The court said, well, when it shifts online, there's greater scope for interference. There's a greater scope that it will not be limited just to the performance based on skill. So we now feel that there's then basically the balancing act between preponderance of skill and preponderance of luck sort of shifts. And they say, well, now this, I think, would fall within the area of illegal or prohibited activities. Now, luckily for anyone who may want to get away with this in Delhi, that matter was withdrawn. So the observations of the court don't hold fast against anyone. But that's happened. That has happened on other occasions as well. So as I said, I think I hope that covers the point. There are many games that have been recognized as games of skill, and there are many that have specifically. There are many courts that have said the same game. There's a difference when it's online and when it's in the real world. So, unfortunately, there is a great diversity in the law. Now, diversity is not good for the law, because one of the key elements of a law is that it should be predictable and it should be stable. So there is, I would say that there's great scope for reform, and there's great scope for clarity on what is in this area.
Certainly. I think there's a pertinent point that we want certainty in the law, but at the same time, something in the state's list is very hard.
It becomes difficult. Difficult. And I think maybe we're planning later to come into the question of reforms and future action. So we'll come back to it on.
Absolutely. So Zafar, I want to build up on what you said regarding the preponderance of skill and the preponderance of luck. Right? Now, borrowing from the Lakshmanan case, this is KR Lakshmanan versus State of Tamil Nadu. Right? Yeah. Now, in paragraph, I believe it's 3, the court says, and this is the Supreme Court of India for our viewership, that there has to be a substantial degree of skill. Right? and which is acquired through superior knowledge, training, attention, exposure, and adroitness of the player. Now, if we're looking at substantial skill, it doesn't have to be more skillful than it is luck, right? Perhaps something like a poker, where the one could argue, I'm sure there is a case to be made for it, that the skill that is required in poker, sure, it might come from all of these aspects, but there is another element to it as well, right? The idea of a certain sense of sort of a cunning or manipulation, for the lack of a better phrase, that, or perhaps even something like a team putty, for example, right? Where one could argue that there is a substantial degree of skill, but there isn't sort of the preponderance of it isn't there, right? So building on that, I want to sort of get on board our next topic, right? If you were to sort of link these, and that is what the current status is, right? In terms of the emerging trends in the related fields where there is substantial degree of skill, or quoting from the Supreme Court judgment, right? So if you could comment upon one, the nature of fantasy sports, right? There's fantasy sports, the leagues where you sort of pick players and they play accordingly. Sure, it's out of the control of, let's say, two people who might get into a contract. Oh, sorry, pardon me. We will leave that for the moment in terms of whether they're getting into a contract and where Section 30 would come into play. But they're entering into some sort of relationship where, okay, if X batsman scores more runs, a certain amount of points is allocated to that person, right? At the same time, these platforms sometimes are, or I think from a very sort of practical standpoint, would qualify as intermediaries who perform this sort of, or provide this service, so to say, to two people or more than two people who enter into that, right? And then there's sort of setting up a team where you compete against multiple people. And if sort of people in the audience are familiar with this, what are known as tournament rules for poker, right? Where you have an entry fee to pay, but the end amount is determined. It's a fixed amount, and the winner of the ultimate game will get a X fixed amount, which certainly comes from the pool, but there is no sort of specific amount. Okay, this is the money that I'm giving, and I'm betting this particular amount on this particular hand, right? So that component comes into play. Would we say that that's sufficient degree of skill, or there's sort of a higher degree of skill in something like that? If, let's say, something like a poker or online poker, if I may, is played through sort of these tournament rules, as they're called. And certainly your comments on sort of the nature of sort of fantasy sport leagues and sort of the role as to where they would fit in this context of the substantial degree of skill.
So I think certainly, I think anyone who's been on YouTube or been on who's used their Paytm recently is familiar with the fact that there's quite an aggressive expansion and marketing of fantasy sports in India, specifically fantasy cricket. The idea in the Western states, in the United States, of a fantasy football team has existed for quite a while, but this is really capturing the imagination in India. At the same time, however, we cannot ignore that there is a certain stigma that has ingrained itself in the last 5, 6, 8 years relating to match fixing and spot fixing in the game of cricket. So there is an interplay here, which I think fantasy sports very artfully sort of sidesteps. Because what one is doing when one creates a fantasy team, you're not betting on the game of cricket. You're not betting on the game of cricket. You're betting on your personal discretion and your personal knowledge of the sport, of the players, of the teams, to build what you feel is going to be the best performing team. So I think now, so let's take the example of I think probably one of the most popular fantasy cricket sport sort of leagues in India. And I give this with the disclaimer of saying that I'm only saying this based on the case law that I'm familiar with, that I'm not advertising any one service over another. So please don't consider it patronage. But Dream 11. So Dream 11 has become extremely popular in recent years. And Dream 11, just for those who may not be unfamiliar, it's just the same idea that Ajay just touched upon, is that people create their own fantasy team. based on certain, presumably certain restrictions and rules that apply in the selection of the team. I'm not as familiar with that. I know that Samir has in the past played a lot of fantasy football, and that's football as in soccer. So he's probably more familiar with how one constructs one of these teams. But I imagine you can't have 11 Sachin Tendulkars on it, for instance. But one constructs a team, and in constructing this team, you use your knowledge, because obviously the point is to get the team that will perform the best. That's where the element of skill and knowledge comes in, of your personal discretion and that distinctive knowledge comes in. As you pointed out, the very wonderful word used in Lakshmanan, adroitness, which is obviously it's a wonderful. I believe French must have been borrowed from the French language, and it's basically it's the personal touch. It's the personal sort of author's right. I think because droit I know is author's rights, so we're talking about basically the intellectual contribution of the individual in the decision. And that's what makes it distinct from just simply placing a bet on whether or not a team is going to win a match. Now, taking the example of Dream 11 forward, that when Dream 11 launched in early days in 2017, the High Court of Punjab and Haryana was a challenge to Dream 11 being illegal came up before the High Court of Punjab and Haryana. In fact, if I'm not incorrect, the background to this was that a person obviously placed a bet and he wasn't very happy about the fact that he lost. And he then tried to challenge the service itself. Punjab and Haryana court said that, well, no, look, this is in the line of games like horse racing, boat racing, and they're all considered games of skill and judgment, and not just simply a game of chance.
Yes.
And that's why it falls outside of the realm of the prohibited activity. And I think certainly we cannot discount the key part that sort of one-arm distance has played. Because if Dream 11 was simply offering bets on cricket games, on various differentiated outgame elements of the cricket game, it would not have stood that. It would not have stood that challenge. That's arguably, if horse racing is a game of skill, cricket is not a game of chance. Somebody does not get up to bat, and that the fact that they're going to score 100 that day is based on luck. Absolutely not. These are athletes. They're conditioned players, and playing every single ball is a game of skill. So I don't know how you could possibly say that cricket is not a game of skill. So that as I said, the stigma of match fixing and spot fixing has played a big part in why fantasy sports could be accepted, but betting on cricket might not be. But there, I'd like to mention, we can go briefly to the 276th report of the Law Commission of India. Now, in a case before the Supreme Court, which was the BCCI versus the Cricket Association of Bihar, the Supreme Court referred a question to the Law Commission to look at the possibility of legalizing betting in India. Yes. This was obviously in the background of match fixing and betting on sports and being a huge issue. And certainly there have been many economic reports that recognize that the scale of betting and wagering in India. So the Law Commission report did a very in-depth report into the aspect of betting. And in fact, they went into wagering and gambling as well. They really expanded the scope of that discussion. In the end, they made some, I would say, very constructive recommendations on how this could be regulated. But they stopped short of saying whether it should be regulated. They did not say that sports betting should be legalized. They simply said that if the government wants to do it, this is how they can do it, and these are the steps they can take. I will mention, however, one of the precursors to this report was the Lodha Committee report, which actually did recommend the legalization of betting with extremely strong safeguards.
Yes.
But yeah, so the fantasy sports are games of skill because they can be considered games of skill because comfortably they have a one-arm distance from the stigma of wagering and betting on games. And the idea there is because if it was openly allowed to bet, that it would the fear is that it would encourage corruption and sort of that sort of the dark element of gambling in the game, which should be considered a the pure spirit of India. So that's the stigma, and that's probably what stands in the way of us getting to where the United States, or at least some states in the United States, where Europe is in its dealing with the sports betting. Yeah. So yeah, I mean, as I mentioned, Dream 11, it was challenged and it was upheld. So now Dream 11 also is considered a game of skill. I should mention that the order from Punjab and Haryana was brought up to the Supreme Court. Now, the Supreme Court didn't deal with it on merits, but they simply declined to interfere. So this also now has the same status as the Lakshmanan, which is at the national level.
Yes.
Fantasy games, like I don't know if we can comfortably say all fantasy games, but Dream 11 at a national level is considered a game of skill. But for a second here to highlight why the diversity of law can be an issue is Dream 11 itself. If you go on the website, Dream 11 itself has a disclaimer that says that our services may not be available in certain states, and very surprisingly, Nagaland is on that list of states. Even though, as I read out to you before, Nagaland recognizes virtual sports selection games as part of their permissible activities. And this is obviously because Dream 11 itself says that we are not sure of the interpretation of game of skill in these states. And there is the chilling effect. There is the chilling effect of the lack of uniformity, of the lack of clarity in the law.
Absolutely. I think that's a very important note. And on some level, that gets me to the next part, that if there is uniformity, or if there is, in one sense, a more tangible, rigid way in which the law can further develop, and on some level, which is already developed, is technology. And the technology that we're talking about today is smart contracts. Right? We've talked extensively about smart contracts on our podcasts and through papers. Just to get a brief idea for our audience here, right? Smart contracts are programmable contracts that stem from the Ethereum Foundation's platform that is provided for smart contracts. And there is extensive writing on this by Mr. Nick Szabo, right, who's one of the pioneers in the field in terms of at least having written about it. And then the Ethereum Foundation, through the Ether token, which is the second largest cryptocurrency in the world, has brought forward smart contracts. Now, it doesn't even call itself a cryptocurrency platform. It's important that the Ethereum website says we are a platform for smart contracts, and that wouldn't necessarily be incorrect, right? And that's where I think the legality becomes interesting, and that's why a stronger case can be made for something like Ethereum as opposed to something like a Bitcoin, which by itself is not illegal either, just for a, or it's not explicitly illegal, if I may. Right? And things have to be sort of told to be a crime before they are to be interpreted as one. But yes, on that note, I would be getting in Mr. Talwar, right? From whom I want to get an idea as to two aspects. Right? The first is the key distinction between smart contracts and traditional contracts. Right? There's obviously the programmable nature of it, right? The fact that they cannot be tampered with, the fact that they aren't as subjective, right? When we talk about things such as public policy or unconscionable bargain, they have to be, ultimately there has to be something that's more tangible in terms of a numerical value most of the time, which is how the code will run, and it automatically executes that contract. But at the same time, if you could shed light upon statutory provisions, not just from the Contract Act, but also from the Evidence Act, which is another different ballgame altogether. But certainly the Information Technology Act, and if you would like to shed some light upon the Negotiable Instruments Act. We were having an interesting discussion about this earlier, and perhaps Section 6, the explanation to it could also, sort of at least a subset of it could be covered. So, Samir, What is your take on the key differences and how we can look at the enforceability of smart contracts in this regard?
All right, so let me start by first saying that the distinction between the two pretty much boils down the intent behind it. So, as you rightfully said, in '97, Nick Szabo had pretty much coined the term what is a smart contract. The definition to it is pretty much, as you correctly said, it's a programmable thing. It's pretty much a program, a code which is written regarding a transaction between two people. The intention behind it was quite rudimentary to begin with. Um, the exact nature of how they explain it is on the basis of an if then model. That if X happens, then Y must follow. So, what they pretty much assumed initially was let's give a simple example. Um, A wants to purchase 5 tons of rice from B. Now, in this scenario, A would enter into this contract with B. Um, B would then go to a lawyer, they would make an agreement, it would be stamped, in certain cases registered, it would be put in the registry, it would be protected in a way. Then B then gets somebody to deliver the products. So once the product is delivered, A will then initiate the payment, it will go to a bank, the bank will release it. There are numerous intermediaries in between. The idea of a smart contract is pretty simple. You make a contract, which is pretty much a code, as which you rightfully said, would be on the Ethereum blockchain right now. They would pretty much say that if B, sorry, delivers the rice, A must pay. As simple as that. The code has it, it is aware of it, simple. One clear distinction what people don't understand is that right now when we think of a contract or its execution, we think of it in the terms of a regular currency. A regular currency, a regular denomination, whether it be rupees, dollars, or whatsoever that we think under. Smart contract, the currency here would be a cryptocurrency, whether it's Ether, whether it's Bitcoin, whichever one it may be. Now, since we're discussing Quay Ethereum, we'll stick with Ether. Now, this contract unto itself, unlike a traditional contract, can self-execute. What means by that is every single aspect which is required to execute and complete the contract for its closure is within that code. Now, just think of it if in an anthropomorphic form that this is an actual box. Now, I've written the code, I've put in a wallet, an e-wallet, which has the requisite amount of currency which I need to complete this transaction. The code immediately says, like, I don't want to dive deep into the technology, but there will be things such as oracles, which are external third-party programs, which will verify whether all the terms and all the conditions required to for the execution and the trigger event has happened. So now let's just assume here that the trigger event, which is delivery of the rice, has happened. Nobody has to write, nobody has to make any give any further instructions. Automatically from the wallet, the money would go away. B is not it does not have to worry upon the contingency of A's payment that is already taken care of. So basically, a smart contract has four basic ideals behind it. Firstly, self-executed. Secondly, codified. Thirdly, trustless, which I think is the most important because in traditional ways of doing contracts, trust is a very essential factor. And finally, the speed of which it happens because no intermediaries, no risk, no nothing, immediately is taken care of. So, four basic differences paperwork next to nil, which was the idea behind Nick Szabo's initial plan of actually doing these things. Secondly, as you rightly said, it's based on a code or an algorithm, not a traditional written format and yada yada, where somebody has to interpret and then take actions. Fourthly, it also has, for thirdly, sorry, there is in traditional contracts a nature of acceptance and offer, and it can be implied, it can be written, yada yada yada. Here, the minute you execute the code, you make the program, the offer and acceptance is made sacrosanct. And finally, this is the key aspect which wherein lies the difference. A smart contract is immutable. What basically means is once it's made, it can't be undone. Everything can be undone, but the process is huge because in a smart contract you've made it goes on a blockchain, it has hashes, it has all these things, it keeps on getting added. In essence, once it's made, it's sacrosanct, you cannot go back. Now, what that immutable nature basically does is that it protects a person with the fact that once I've made it, I'm secure, it is done. The minute I complete the transaction from my end, I'm protected. No intermediary, no third party reference, nothing. Simple. Now, just coming que the various laws that now I will teach individually. Now, here is assuming that a contract is made in this nature. Person A and person B have entered into a smart contract to provide certain services or products in return of which a consideration has to be given. Now, under contract law, we've defined what is a contract. If you go to section 10, section 10 simply says what agreements are valid contracts. Now, in that, what is required? First and foremost, you require free consent, that an offer and acceptance. We are not going the initial parts, what offer acceptance. I think the viewers would know this. So it should be done with the free consent of all parties who are competent to enter into a contract. And these are the two kickers for a lawful consideration and a lawful object. As long as these are made, it is fine. As long as these four requirements are there in any agreement, it is a valid contract, subject to laws and whatever is in the contract act and various other laws. These are the four basic requirements. Now, looking at a smart contract, two parties entering with free consent, free will, they are competent to contract as long as the consideration is lawful, perfect, as long as the object is lawful, perfect. Now, to describe this distinction, right now we're assuming that party A and B are buying rice and selling rice. To take this discussion forward, what Zafar just said, now I can enter into a similar agreement for betting on horse racing or wagering on horse racing. Now, if I wager with party XYZ, whether it's written in the English language, whether it's written in code, is the same thing. If A happens, B must pay. I bet on horse XYZ winning, XYZ won, game of skill, B automatically pays. I don't have to worry, it's already there. It will be taken out of the wallet, it is done. Valid contract, valid process, everything sorted. Suddenly I decide I want to do a similar wager, quick cricket or football or any other game. All the four components are there. Only one is taken away, which is lawful object. So technically, it's no longer a lawful contract. So the Indian Contracts Act nowhere stipulates how a contract is to be made. Nowhere does it stipulate it has to be made in writing. Nowhere does it stipulate it has to be made in a particular form of writing. Nowhere does it stipulate that it has to be in a particular format or draft, as long as these four minor conditions are there. So, on a very cursory level, smart contracts can be contracts. The next thing is, we've touched on law of object. The next thing is
Enforceability.
yeah. So let's assume it is under contract law, it is absolutely fine that it has crossed that first threshold. Now comes down to enforceability. Now, first we'll move to Information Technology Act because it's easier than the Indian Evidence Act than Information Technology. Now, the Indian Evidence Act, you need to look at 3-4 sections. Most predominantly, you need to look at section 65A and 65B, which were introduced because a lot of contracts were on e-contract or on electronic record, and most of our lives are now on electronic record. Yeah. Whether it's emails, whether it's acceptance, whether it's change anything, everything is in e-record. So it's a pretty simple 65A pretty much says that it's a special provision where evidence relating to electronic record is being acknowledged, and 65B is the requirements which must be met. Now the issue which comes here is 65B is very old school still. Oh, I'm so sorry. It is quite old school. Now 65B actually foresees that, all right, you need to produce a computer for me. You need to give me the machine on which it was recorded. You need to show me the ownership of the machine. Need to show me so many things. We've not gone into the fact that you need to show me what server it was on. You don't need to show me um, what data, what service provider it was using. Nothing, just the actual machine. Now, a smart contract, to be honest, and the technology behind it is far smarter than our law and where we are at. The issue here would be pretty simple. How do I go and show to a judge in evidence under the current law that this is how a smart contract works? I can go and say that when I made this contract, I was on my laptop, this is my laptop, this is what was made, and yada yada. But the server is somewhere else. And how do you show to a judge that this certain random numbers that I've made which show the intention behind it is sufficient and the payment is through an e-wallet and yada yada. So under 65B or under the Indian Evidence Act, technically a smart contract is again not breaking any law, but have we regulated it? Do we have the terms and the knowledge whereby we've said, okay, we know how to acknowledge and we know how to govern it and we know how to show this as not, let's not even go into primary or secondary evidence right now, as evidence. See, because a smart contract, because of its features where it's stronger and more unamendable in nature or unmitigated in nature, the question of whether it's primary or secondary evidence should not even come. It should be one of the safest ways of assuming primary evidence that this is a proven document. But under 65B, we have not analyzed it, we have not thought of it, because how many of us even know of it? So it'll take time for the Evidence Act through legislation and through understanding and technology to actually bring it in. I do not see any reason why it should not be brought in, but it will be brought in once we have better understanding. And of course, our current reliance on machines and ownership and yada yada has to go. Now, along with that, there is 85B in 85B in the Act, which deals with basically the signatures and basically how an electronic record is kept and what are the signatures. Now, to come back to signatures, now we have to go to the IPA Act. Now, the IPA Act under Section 10A uh, valid speaks of about the validity of contracts which are formed through electronic records, electronic means. So, two things we must keep in mind. First of all, this contract is valid under Contract Act. The only difference is, as a traditional contract, as we used to see it, written in physical form, yada yada, and all of this. Now we've gone a step further. This is where our law has gone to its uh, technological zenith. That under Section 10A, we now see that if something's made by email or something is shared, as long as there's a record and it shows all of the necessary prerequisites of a contract under Contracts Act and the other laws, it is sorted. For this now, then we have other sections which deal with digital signatures. What is a digital signature? Who can actually authorize a digital signature? Who can actually validate and give a digital signature? Now, a smart contract does not need a digital signature. Let's be honest. The very fact that I went to the Ethereum website, the Ethereum blockchain, I paid the gas, what they call the gas money, which is basically the cost for making the code. I put it up, it's already there. There is no digital signature. So again, the IT Act must make this distinction that while they acknowledge what a e-record is and what a e-contract is and its validity, this distinction creates the definition of the law and what it needs to protect, and the technology has to come. In essence, all of the requirements whereby a smart contract has to be valid are there. It meets everything. All we need to put is the regulatory aspects of it, wherein the technology has to now be acknowledged and brought in within the purview of the regulation of the law. So that is where we are at.
Samir,
Next, I
sorry, Samir.
yeah, please.
Yeah, apologies. If I would come in again, an interesting point made here
Yeah,
regarding the question of digital signatures or electronic signatures. Now, the definition that's in the ID Act might not sort of squarely get us to what is the ID or the address when it comes to Ether tokens, but
yeah,
there is a requirement of, as under the ID Act itself, uh, for the digital signature, and which is also valid in the case of smart contracts, that is asymmetric crypto information, right? Which is effectively a password ID.
yeah.
You hold your own address.
So that
So
is section
that
35 and
is something
37
that's
you're
sort of
talking
put
about.
forth.
Yeah.
Yeah.
So see, if we go into that, it'll be too technical. Right now, the law is not even close to it. We are not even close to it. Let lawyers be. Let law be. Lawyers aren't even close to it. Very few understand what it is. So it'll take time. Um, One thing which you said, which was quite interesting, was the term tokenization. Now, just to explain to everyone how a smart contract would work, and I'm just coming back to the very basics of it. See, the idea of a smart contract right now is on the fact that every asset, as we know, can be converted into tokens. You see, people won't understand right now that for a smart contract to work, let's take buying and selling a house. I can say that I've agreed to this thing that I'm buying this house with this much value and yada yada and it's done. Again, it comes back to the currency aspect. once we allow every asset to be tokenized, which is whether in the form of Ether, Bitcoin, any other thing, that is where all of this can come in. Now, digital signature is not sufficient for a smart contract. A smart contract does not see this. A smart contract basically just assumes that the fact that Ether has made it, it has overlooked it, or whichever blockchain has made it, it has seen into it that nothing has been overlooked. Everyone's proof of identity has been done. Thus, oracles come in, which is third party um, executor who will look into all these aspects. And once we figure it out, it's done. Maybe there is something new which comes out. Maybe once this technology is taken up, digital signatures become obsolete. Initially, when people were moving to e-contracts, we did not know what digital signature was. People were still signing and then scanning and then putting the stamp and still doing it. And somebody said, wait, there's a simpler way of doing it. I'll give you a very small pen drive which carries a very systematic number, which is only identifiable to you, which is given by the MC and the government of India. We have authorized it and it's done. Now, whether a new method comes in wherein they read it into a smart contract and say, okay, you need this essentially, or they come up with something new, that is not uh, a discussion for today because that'll require a lot of technology into it and a deep dive into all these things. Now, your question, Kwe, the Negotiable Instrument Act. Now, there is a very interesting thing which was done, Kwe, Section 6 itself, under the Negotiable Instrument Act, that under the Information Technology Act, Section 1, Subclause 4, I think, right with the first schedule, gives a list of items which are beyond the scope and purview of the IT Act, which also reads the Negotiable Instrument Act within it. Subsequently, Section 81A was added, wherein they said, no, electronic checks and truncated checks, as is under Section 6 of the Negotiable Instrument Act, will be within the purview of it. But now, what is an electronic check? Now, electronic check is something very rudimentary again. We are again playing with very old technology here. It is almost a copy of your physical check, on which instead of signing with your actual signature, it's a digital signature. It's not something very smart. An electronic check is basically a mode of payment, which in this case would be the e-wallet. An electronic check is nothing close to a smart contract because a smart contract here would pretty much be a bunch of things. Let's just take it again, the old example of rice. A smart contract would include A, pretty much the terms and conditions of the contract. It would also include B, the method of payment. It would include C, what the banker or the escrow agent or whatsoever the payment method is, it would include that in it. D, it would include the registry, which would keep a record of this. 5, it would be the MCA, which keeps a record of all your things. So it's basically a smart contract. The best way to explain is the decentralized nature of it. It's the decentralized ledger technology is a smart contract. That everything what a normal traditional contract and mercantile system we understand is put on this one database. Database is also too simplistic a term. This one behemoth of a very small thing, which keeps on sharing everything. I don't need to go to a list. I don't need to go to somebody else. I don't need to go to an authority to say, oh, this was my contract. I made it first. The other modification is incorrect because it can't be modified. It is time stamped. It is kept. It has with so many different people. And by people, I don't mean individual actors, but everyone on that blockchain, that it's protected by everyone knowing about it. It's a secret that everyone is aware of. Thus, it is no longer a secret, and therefore, everyone can vouch and validate that what A is saying is true. B is now changing, which was never allowed. So it is very interesting. It is a revolutionary technology. Now the question is, to what extent do we take this revolution? Do we try to bring it within the ambit of existing laws, which is there is a very interesting term which is used, which is the law of horse racing. And I'm just bringing it here, horse contract, which basically means that the law is already there. Everything is already understood. There is a new technology, there's a new understanding, there is a new mode of doing it. We just need to read it into the existing framework and protocols which are there, and we are good to go. The other is that no, this is something very new. We don't understand it. Our existing laws and procedures are not sufficient, and thus we must come up with something new. I, in my opinion, believe that we already have sufficient legal framework to A, acknowledge the validity and authenticity of smart contracts, to B, even bring it within evidence law. See, under IPA Act, even acknowledge it. All we need to do is that there are certain specific and nuanced features, which is very new and very novel to this technology, which should be read into existing laws. Of course, we can make whatever regulations according to it. Now, just to come back to it, you had said, I said, and you had also initially picked up on it, that these are based not only on blockchain, but currently a smart contract in essence is based on Bitcoin or Ether and yada yada. The RBI initially, if you remember, had said that we don't acknowledge it, and they pretty much put a stopgap. And then for create the Bitcoin issue and cryptocurrency issue, API was filed before the Supreme Court, which I think the order came on March 4th, 2020, where they've said, boss, you need to regulate on this, you need to acknowledge it, we need to figure out something more. You can't just do a blanket no. I think we are a little far away. I think the regulators have to come in. As much as we would like to say that, oh, this is decentralized and people have absolute freedom and yada yada. No, we need regularization. There'll be issues of, see, right now we're looking at simple contracts. A is doing a trade with B, X. If X happens, then Y must happen. But contracts are not like that. Just imagine A was doing a contract with B, but somebody else has a right of first refusal or right of first offer. There are certain things. See, there is right now what the only thing which a smart contract technically can do is a very objective and specific contract. But contract law and human nature and industry is very subjective. How would a smart contract look into the rights given in a shareholders agreement or a share succession agreement? How would it look towards various JVs? How would be an SPV created? Wherein there's a dispute. Okay, a simple thing as a loan. Let's say you enter into a smart contract with a bank. I need a loan. Brilliant. Let's say we even convert everything into Ethereum or a cryptocurrency where a wallet is made and everything is done. Nobody's going to keep the money always in that wallet. It's going to be taken out. It has to be utilized. The payments have to be given back. What if the person does not have sufficient funds in the e-wallet? What if he'll say, I'll put it later? All these issues. Since it is so in black and white and it's immutable, and once the code starts it, it is done. A small error or a small distinction, which is required, a small amendment, a modification, it won't allow. Just imagine if all the contracts prior to COVID were smart contracts. Just imagine for a second. Y2J would have been a lesser fear because Y2J was just imaginary. Y2K was imaginary. This would have actually happened because the program would have simply said, you were not able to complete this. What is force majeure? We don't know this. We can't interpret it. Everything stops. Your electricity would have switched off tomorrow. Your bank loans would have gone. A moratorium is not possible in a smart contract as it is envisaged today. So there are many real world implications which have to be looked into. It's exciting technology, of course, but as it stands right now, it is very simple technology, and people are working really hard to make it grow, to get the analysis in, to get the programs to that extent that they can interpret and analyze and deviate on their own if the need be. I see you have a point which you want to bring up.
Not at all.
Please.
Yes, I was going to give
if I can jump in 1 second there. In fact, Samit made a great point on this immutability, the lack of subjectivity in a smart contract. Now, I might disagree just a little bit because he's completely correct about the state of the art now. But when you break something down to code, anything, I suppose, with enough ingenuity and effort can be coded. But just like our system of governance recognizes that the legislature can never legislate for every eventuality, a coder cannot code for every eventuality. For example, to take up the example that Samit just raised of the force majeure clause. Maybe the smart contract does have a force majeure clause that has been specifically coded. It provides for every act of God under the sun, and it provides that there will be a flood. And an Oracle type third-party software verifies whether or not there's been a flood. But maybe your house got washed away by a mudslide.
Yes.
The smart contract won't recognize it. A court will say, flood, mudslide, it's the same thing. What do you mean you're not going to pay out the insurance? But a smart contract will say, no, the terms have not been satisfied and your house is gone.
Just to add on to what Zafar was saying, that now another thing which is touted a lot about smart contracts is that
there is a request from the audience for you to kindly adjust your microphone. There's some problem with the audio.
Wait, can you hear me now?
Oh, I think,
Can you hear me?
yeah, I
Yeah.
think we can hear you clearly now. I think maybe because you're using
Yeah.
the hands free, maybe it got caught
Yeah,
somewhere.
got
Yeah,
it.
yeah. I think
So,
it's
all
good
right.
now. I think.
Now, another point which Zafar brought up, and it's usually touted about smart contracts that, oh, in case there is any violation or breach, or if there's any penalty, this will happen immediately because you don't need to go to court. It is self-executing contract, so it'll rectify any error or breach, and it'll just continue. That is just again assuming that it's a simple, plain vanilla contract that A was supposed to do something, B was supposed to pay in reply to it, and we are done. The event didn't happen, there was no trigger, there was a breach, and simple. But again, just coming back to force majeure. Now, let's say the coda had put in force majeure, and the coda had also put in a frustration clause into it. It took us months to figure out whether COVID was force majeure, whether this would apply to frustration. If you don't have a frustration contract, are you protected under force majeure? Whether a pandemic is a force majeure, whether COVID is a pandemic or an epidemic, all these questions. Now, while a court can do that, while a lawyer can do that, while you and I can even say a code is made, the coder would have said, "Oh yes, I would have done this," but we can have we can even have a modicum of a code is very exact in its nature. So it will take time. It will take a lot of ingenuity and engineering when we get to complex legal issues. Just to sway back to what our conversation initially started with, Zafar. Let's just take the example of gaming contracts. Kings, Dream 11, yada yada. So I remember reading up way before we had fantasy cricket and draft leagues in India. This started with this thing called DraftKings in the US, where it was being done for American football, um, which is a version of glorified rugby, according to me. Um, but nonetheless, so in American football, you could make your team. It was regarded as a game of scale. You weren't betting on an eventuality that team A or team B would win. You were picking players out of both of them, or picking the best players out of everyone who's playing, and you make points. It's exactly the same as Dream 11 works. Um, but here's one thing that we tend to overlook. There are people who truly made it into a game of skill. They're looking at analysis, they're looking at statistics. They've given up their jobs. These are mathematicians who should be working for MIT and Yale, but they rather be doing this because they're making huge amounts. At the same time, it can also be argued that the other guy who's doing it has no idea and he's just going on a feel. Or he just thinks simple things that, oh, Kohli will be in a good mood today, or I think the pitch has an issue, on simple things. So now, while all of this is there, a smart contract would be perfect for this scenario because right now you're relying on Dream 11 or whichever the other things are. I don't play all this, so I don't know the names. But right now you're relying on the intermediary to actually complete this transaction. So I would pay Dream 11, or even if I'm playing on any poker side, I would pay there. I would buy the token. I would then or enter into a tournament, and that would go to the intermediary. The intermediary would then ensure that once the result is there, it's given to my account, and yada yada yada. Here I've removed all of this because I bought the token, whether it's ether or whatever. The contract is made. The minute I win or minute somebody else wins, it is done. So see, it has very simple application right now.
Yeah.
I think people are very excited about what all this technology can do. But I think what happens with human nature is whenever there's some new technology out, initially we are too overexcited and underwhelmed, and eventually we just lose interest because it wasn't a panacea and it wasn't one stop cure for everything. We need to take it slowly. We'll find out a ways. It will improve, and yeah, it'll be a mixed bag. But this whole thing that you would not need lawyers or you will not need courts and everyone, A and B, you can be sitting anywhere and doing and enter into any contract, and territorial jurisdictions or issues of other issues, jurisdiction or jurisprudence will all go out of the window. That's never going to happen. I, for one, believe that will not.
One could almost say that's reassuring for lawyers and law students. And on that note, I want to get in Zafar on this as well, right? And we sort of merge the two areas that we have been discussing, right? We've been discussing wagering and we've been discussing smart contracts. Now, sure, on some level, there is a certain level of contingency, if I may, drawing from section 31 to a smart contract in the sense that X amount of Ether token is going to go from A to B if XYZ conditions are met. Sure, that part's covered. But I want to get to the meat here at section 30. Now the key dilemma before us, Zafar, I'll get you first in on this and then we'll get Samer, is that we enter into a contract, right? And I will give two examples here because I think both of them are fundamentally different. One is a smart contract where we sort of engineer a transaction where if, let's say, Delhi wins, X person gets the amount. And where if, let's say, Bangalore wins, the other person who's entering into that smart contract gets the amount. Now, as soon as the match gets over, obviously it's coded into it that as soon as the match gets over, it takes up the result and that amount is automatically transferred. Now, that's one nature, right? Now, what section 30 says is the word used is void, right? That wagering contracts would be, or agreements in the nature of sort of wagers would be void. Now, what's going to happen when that transfer of funds has already taken place? Number one. Number two, the other direction I want to take, and I think it's slightly different, or perhaps you could clarify for our viewership as to whether it's not different at all, is the ogre token. Right?
Yeah.
Now, the ogre token, to come up with an example here in terms of sort of, let's take up the example of, let's say, betting on the United States elections. Right? Now, let's say the value of the token is adjusted to the probability or the chance that is considered that X person is going to win. Right? So let's assume that a Biden token is selling for 60 cents to the dollar, right? Or selling for 60 cents. And then the Trump token is, let's say, selling for 40. And at the end of the election, one of the tokens is going to become zero in value, whereas the other token will become $1 in value, which is effectively very different, at least in my view. Please feel free to say if you think they are the same. In my opinion, it's a very different transaction. Sure, the application of it in sports can also come in a similar manner, where the odds are adjusted in terms of the rate of the token that the person purchasing it gets into. And for our viewership and for those who aren't aware, Ogre is one of the tokens which is built upon the smart contract platform provided by Ethereum. So, which provides this sort of smart contracts, if I may, right? So, for example, A and Z enter into a smart contract to purchase that one Ogre where we contribute 40 and 60, let's say. And then that I get that one at the end of it. So, where do you think this would come in? And how does sort of section 30 play into it once the transaction is completed? Do we sort of go back to court and say, hello, this is void and I need to get my money back because I lost? So how is that going to develop?
So I think there's so certainly two factors there. One is that to try and predict how a particular regime or a particular jurisprudence is going to respond to such questions is you have to ask yourself whether or not they'll understand the distinction. Now, somebody may come up with an extremely novel argument for why this is not basically just a wager on the blind happening of a thing. But if the court sees it as akin to a wager, then that'll end up being your answer right there. That's the more practical. That's the more practical answer. To come to section 30 and to 31, how those will play. Section 30, now it says agreements by way of wager void. Void, not illegal. So what does that mean? Actually, again, in a practical perspective, what does that mean? That means this agreement can be entered into, and people do enter into such agreements, but that the court will not enforce it. So again, as you said, in this scenario, if the person who lost says, I want a refund, he's not going to get it. And if the person who won says, I didn't get paid, he's not going to get paid.
So that's just a small point, quick point to this. What if they were to sort of, let's say, go down the specific relief route and say, okay, this is a void contract, I've paid something and I want it back.
So, well, again, the court is going to, we'll have to look at the specific relief act. So the court will say a void contract cannot be specifically enforced.
Hmm.
So that again, that will end up being the answer. So it's a bit of a game of word association, you know.
Yes.
All right.
Like void
So,
not legal, but specific performance not of a void contract.
Okay, just to add to what Safar is saying, I think we're just looking at section 30 and 31, but let's look at section 20 and 21 also.
Yes.
Now, section 20 says mistake of fact, and section 21 says mistake of law. Now, just going to the Ogre token example, I'll come to what my opinion and beliefs on all of this is a little later, just going on the law right now. A mistake of fact which would make it void ab initio, and let's just think, okay, section 30, we are not interpreting void ab initio as illegal, but so under section 20, a mistake of fact would be that if I'm betting on the US presidential election, but I think it is Donald Trump versus Sanders, which is a mistake of fact. It makes us completely void ab initio because you were confused. But I'm betting on Biden and Trump. I just didn't know that the law did not permit it. There was a mistake of law where I thought, oh, this would not amount to wagering because I would think this is akin because the value keeps on changing on on probabilities and on poll reports and yada yada. This would be quite similar to how, let's say, everyone is currently in the rat race to make the first corona vaccine. So whether I am buying shares of Pfizer, whether I'm buying shares of Moderna, whether I'm buying shares of, let's say, uh, a third AstraZeneca, whoever makes it first is going to get an astronomical return, which is akin to the $1 who upon the winning president, and whoever doesn't make it becomes the losing candidate, and they lose all the money. So if I bet $100 right on AstraZeneca, and somebody else has bet $100 on Pfizer, and AstraZeneca wins the race, I suddenly get my money, my return. So it can be looked at. See, you can look at all of this. For instance, even coming back to now, horse racing is regarded as a game of skill because you look at the horse, the conditions, yada yada, the jockey, everything. Why is it that plain vanilla betting on the result of a game, or betting on how many runs a batsman is going to score, or on the fact that how many runs a bowler is going to go for, or how many wickets he's going to take, why can't that be a game of skill? I'm betting right now that in, like, currently the IPL is going on. I wonder if anyone's watching it, but I of late have been because I don't know. I just refound my love for cricket, it seems. Um, Now there are three stadiums they're playing on: Sharjah, Dubai, Abu Dhabi. If there is a game happening in Sharjah, I am betting big on the fact that a lot of runs are going to be scored. Not because of anything, because I have a feeling, because the Sharjah ground is smaller. If they're playing in Abu Dhabi, I'm betting big that a particular bowler who's good at spin is gonna actually kill it today because Abu Dhabi really helps out. If it's a game in Dubai, I'm betting on the fact that it is a great game which is gonna happen where the runs are gonna be restricted. There are so many factors. All right, one player has had an injury. He had certain confidence. There's certain negatives. Amit Mishra hasn't been doing well. He's a great bowler. I can bet on the fact that he's not going to do well against an edge batsman
Samir,
because
I'm
he's
going
good.
to ask you to kindly adjust your mic again.
All right, can you hear me now?
Yes, much better, much better.
Yeah, sorry. So then the issue is I'm gonna bet on Amit Mishra against Amit Mishra because he is not great one type of batsman or left-handers or right. So these are intelligent calls which are being made. These are not random. We are not betting. I think if you can regard horse racing as a game of skill or poker for that matter, at every hand if one is betting. See, spot fixing is a very random thing. That is absurd. That is purely on luck, like, okay, this ball is going to be a no ball, this is going to go for a six. That is random. But even if you take football or you take American football, you take any sport, there are intelligent guesses that can be made. I for one support this team called AC Milan in the Italian league. Now, if I had to bet in a game that there's a footballer called Gattuso who's going to get a yellow card, it's a very good bet. He is an enforcer. He's not a very technical player. He's a very aggressive player. His job is there to bring down somebody if they are going for it. In the midfield, his job is there. If there is an attack happening, you stop it by any means possible. You'll get a yellow card. It's a pretty decent guess. I'm not just guessing it on some random thing. If I have to guess that, is Manchester United going to bleed goals right now? Yes, they are, because the defense is in shambles and Harry Maguire has just come out of jail. So all these things are there. Now, if in essence we get the fact that this doesn't amount to wagering, this is beyond the purview of Section 30. This is absolutely fine. whether you do it as a traditional contract, whether you do it as a smart legal contract, whether you do it in the current format, which is how we do e-trading and e-contracts, or whether you make a smart contract, it really shouldn't matter. The enforcement is fine. Now comes the question of how you said that Ethereum has gone and there is the ether tokens have passed away, have been moved on, and payment has been done, and now you want to
Yes.
go to court.
Yes.
If I think, see, herein lies the irony of the smart contract debate, because I thought the whole big point of smart contracts was we didn't have to go to court; they were self-executing, they
Yes.
protected themselves, and here now we are realizing that even a simple thing as this is not protected. Because see, humans will make a contract about anything. Let's not call them contracts; these are transactions.
Absolutely.
If now we are going into whether this transaction is valid or not, and that's where it comes into a definition of a contract. We are being very simple here in saying that this technology will only be used for good things, that all right, we can make these we can have these like recently I think the United Nations in Africa did a program where for the refugees, the payment was done through cryptocurrency, where unique identification number was given to each one of them. It was done through facial recognition and eye scanning, and once they got it, they all got their coupons in the nature of ether, and then they could pay for various other things and utilize it. It's a very good thing. You're taking away the middleman. You're taking away the numerous uh, idiosyncrasies which come in nature, and they're not always very good. Um, but that being said, coming back to the wagering thing, if the law regards it as valid, it should be valid. Now, whether the law should regard wagering valid, skill or chance depends on me.
Well,
So,
the law commission's already chimed in on that particular aspect, and
Yes.
obviously, as I said, that we're talking about the 276th report. Now that's a couple of years old already, so I think in a way the answer is before us.
actually, if I could add, the beauty of that report is that in the 276 report, you would think that they're saying, okay, you should regulate it and you should create a legal framework. And a few days later, clarification came from the committee itself. We never intended that. We said that if you want to, you can. So the recommendation, they've also backtracked. So this is where we are at actually, where we are really nowhere.
So, this is sort of summarizing both you, Zafar, and Samer, right? On some level, I think all three of us can be in agreement on both these aspects, that there's a need for sort of new progressive legislation, both on the end of smart contracts, that is the IT Act, the Contract Act, perhaps the Negotiable Instruments Act,
Yeah.
certainly the IT and the Contract Act, right? At the same time, the other form of the legislation, and Zafar, I'll go back to you. Perhaps we'll take just short concluding comments as to what the future should be looking like from both of you before we take a couple of questions. Is the betting, gambling, wagering aspect of it, right? Ultimately, sure, perhaps that has to come more from the states than the center, the union. It's going to be a list two aspect after all, but perhaps there's separate legislation required in that direction as well, to come up with, let's say, either more uniformity, certainty, at the same time, a more progressive approach that, listen, the courts have been looking at this favorably. And at the same time, it helps better regulate this when you can institutionalize it properly, right? The idea that such activities will uh, fund illegal activities otherwise, whether organized crime or otherwise. Um, at least sort of institutionalizing it will perhaps even raise the tax revenue for the
Yes.
you and cry about, oh, we need a big G in the GDP formula. The government needs to sort of spend more. So Zafar and Samir, just some sort of short concluding remarks regarding what the future should look like. What, sure, I think whether there is to be new legislation, I think everyone will agree on, but how and what are the aspects that they should be focusing on, following which we'll take a couple of questions from the audience.
Sure. So, just to handle my side of things, it is undoubtedly that some sort of regulation, some sort of legislation is necessary. KPMG, in a study done in 2011, and this is 2011, they found that the amount of revenue generated by wagering and gambling in India is close to 60 billion US dollars. So it's 2.5 lakh crore. And a majority of that is illegal and unaccounted for. So a follow-up study by Deloitte for looking at the 3 financial years preceding 2016-17 said that the legitimate side of this is around 800 crores. And that's seeing significant growth in the virtual game sector, in the fantasy sports sector, in card-based game sector. We're looking at 700. Let's pump that up to a nice even 1,000 crores versus 2.5 lakh crores. So it's undoubted that we cannot just banning it is not working. Okay, and I know that there are recent debates in the media, in the discourse on many other similar things, where we have to start recognizing as our society changes, as our value systems change, and as we become unalterably more globalized, simply banning it does not work. Something is necessary. Now, yes, there is an impediment to this change at the national level, which is that this is in the state list. Some states have taken great strides and liberalized. Some states are moving backwards. Now, what can the government do? What can the legislature do? The legislator can still certainly look at a model law. They can certainly still at a union level put out recommendations. Recommendations can be made. They can, if nothing else, adopt the report of the Law Commission. The legislator can at least say, we adopt these recommendations and ask the states to consider them. I think those are some big starting steps.
Samir.
So just to add to what Zafar said to close, now, till now we could ban it and say, okay, none of this is happening and it doesn't happen in India, which is not true. But I think a regulation is really required because right now anyone can bet, including minors and people who should really not be betting.
Absolutely.
But so we need, and let alone the fact that the taxation and the revenue which comes in, the regularization would really help. Another thing which has been happening, which we very nicely been overlooking, that people still bet in India, that too legally. But a few of them, what they do is that they are betting on websites which are or bookies who are not in India. It just so happens many people in India do have foreign accounts, and they are betting through that. Now, till now, that many people was a very small number. What this smart contracts or blockchain permits is anyone can buy Ether. You don't need to have a bank account in Europe, or you don't need to have a bank account in Singapore or America to bet anymore. You purchase this, you make the contract as you rightly said, it is executed. The person who wants to bet, who wants to wager, will utilize this. They are not going to the court. They're very happy. No one is going to the court against Bet 365 or anyone. They just want to do it. It's a habit. It's a habit. It's a need for them. Now, this new technology provides them a very way to fuel that addiction. And therefore, it is necessary for the regulators, for the executive and the legislator to wake up to the fact that this is going to happen. It has become much more easier. And before it gets ubiquitous and too late, we need to get on this, at least to the limited extent of the discussion that we're having today, that the existence of smart contracts has made wagering and betting across the world far more easier for Indians who do not have a bank account somewhere in the West.
Yeah. I guess that's how we would say that the law is supposed to follow the merchant, but the merchant is going to follow the technology, and the law needs to catch up to the technology as well on some level. Now, on that note, I think one thing that I would like to bring up here is that I'm reminded of Mr. Silvai's comments in his masterpiece on constitutional law regarding the Chamar Bagwala case and the RMDC case. And he's written extensively about that from a 19(1)(g) point of view. On some level, somehow the position is that when the state does it, it's all right, right? And when the individual's trying to do it, it's a big problem. So much for us to say that in the eyes of law, the government as a litigant is the same as an individual. Perhaps the sort of real world is not so much the same, right? On that note, I'm going to get the next question. Sorry, Zafar, would you?
No, I just had a quick thought on that, which was that the law is what the law is.
Yes.
So the law is that gambling is banned except for lotteries. So that's why. So why can the state do it? Because gambling is banned except for lotteries.
True. I think, and that's a very important one, which is quite linked to my next question from Mr. Arjun Krishnan. And for our viewers, I think this has come up one time or another. Dura lex sed lex, right? As Zafar says, the law is harsh, it's the law. So Arjun Krishnan's question here is, why is blackjack not typically recognized under the preponderance of skill arguments? Now, a game of 21 or blackjack for viewership and for panelists here, there is a certain, I mean, sure, there's a concept of card counting or sort of weightage given to specific cards. And for viewership, this is why sort of cards are given by a dealer, and you either the highest card number wins, or if you're 21 and above, you lose. 21 is where you win, and above you lose. And sort of counting the cards and sort of weighing it is effectively the skill that's involved here, right? I don't know about the specific schedules as to where blackjack or Game of 21 is recognized. Zafar, you brought this up earlier. So any comments on this as to...
I think, again, so the point that I had sort of touched on earlier is how a game or how a game is understood in terms of what it involves and where is the level of skill. So there's no doubt that blackjack involves skill. But I think the practical answer to this question, Arjun, is that why is it not typically recognized is because no court has dealt with the question yet. As far as I'm aware, no one has gone to a particular court and raised the challenge and put their own money behind a lawyer and said, recognize blackjack. Now, poker has been recognized because somebody went to court. Dream 11 has been recognized because somebody went to court. Horse racing, somebody went to court. And rummy, somebody went to court. So the practical answer is, why is it not recognized? Is because no court has ruled on it yet. I also, by that logic, can't tell you that it can't be recognized. The Nagaland, if I can take you very briefly to the Nagaland Act, it, like as I had mentioned, it is a very expansive definition. In fact, it says that in games of skill shall include all such games where there is a preponderance of skill over chance, including where the skill relates to strategizing the manner of placing wagers or placing bets, or where the skill lies in team selection, etc. And in its explanation, it says that any game which a national or international court recognizes as a game of skill, or where there are national or international tournaments, is eligible to be entered into the list in Nagaland. So Arjun, if you make a representation before the Nagaland gaming board, perhaps it could be recognized. But why is it not recognized? I think is because the element of skill that is involved is extremely unseen. For example, people who count cards in Vegas, which is where gambling is legal, counting cards is considered illegal, or it's certainly considered something that you'll get kicked out of the casino.
The house looks down upon, right?
And
on some level,
it might be considered unethical. So can something be legal but unethical? Larger question.
So I think Zafar, was absolutely a very strong point there. On some level, everyone who's approached the court has been a big party with a lot of skin in the game, and effectively is the house, right? Whether it's these platforms or intermediaries. And the question of sort of blackjack is that the person who says that I want to employ my skill is not the house here. It's the person that the house says, listen, I don't want this guy.
Yeah, in fact, the most skill that is involved in blackjack is completely, you're right, it's completely against the house. Because blackjack is one of those games where you're purely playing against the house. It's not like poker where you're pitting your skill against someone else's skill. You're pitting your skill against the house's luck.
It's just like Zafar picked on rummy, so it's the same equation. Like poker, game of skill, blackjack not. Rummy, game of skill, teen patti not. Because teen patti and blackjack are supposed to be games of chance. And you can argue it out, but how many people who are going to play blackjack would have the skill of counting cards? So
it's extremely hard. And in fact, I think the bigger factor is it can't necessarily be done alone. It cannot be done by a single person. So that again is probably a factor in.
No, it can be done by single people.
I'm sure the facts were sort of.
Yeah, but Hollywood. Sorry.
No. When I say it can't necessarily be done alone, is because there are other people involved. When you're playing blackjack, you're not playing one-on-one against against the house. Your counting cards, in fact, the luck in blackjack is influenced by how other people around you play.
Blackjack you can play one-on-one against guys. Yeah,
No,
but
you can count cards on your own. For instance, if the person before me, if I mean, I have a little bit of experience. I'm sorry if I'll admit to this. Now, if the house, if the dealer is holding a 6, and the person next to me has a 10, and they hit, or if the person after me has a 3 and they hit and they ask for another hit and they busted a 23, and it's a card that may have busted the dealer because the dealer has to hit on 16, it's influenced my chances of play. It's influenced.
I'm sure that sort of doubling down or splitting, etc., adds to a significant component of skill there. But again, without getting much into it, another question.
I think the key phrase is preponderance of skill. I think that's what will always come down to.
Absolutely. Is another question is regarding somewhere either of you could sort of come in on this, is regarding the taxation question pertaining to smart contracts. Right? And now, sure, the regime on this is still developing. For capital gains on cryptocurrency transactions, sure, that's there. But now, if a transaction sort of takes place and the contract itself has your medium of exchange, which is the Ether token, let's assume there's sort of hundreds of millions of sort of dollars. And that's the beauty of the technology, that a huge amount can be transferred fast and at a very negligible cost to the parties at least. Right? What's going to happen about taxation?
Yeah, so this is assuming the fact that we have legalized and acknowledged that the cryptocurrency is valid.
Absolutely.
Assuming.
Absolutely.
We should treat it as we treat foreign exchange. The value on the day, the timestamp, as simple as that, and the valuation is on that. If the transaction has to do in dollars and it is done on 23rd September, we look at the exchange rate that day and it's clearly known. Same will be with these currencies, that they would be instruments of value, and their value will fluctuate. So you take the value on the day. See, the minute we regulate it, we're not regulating it because the state wants it to make it easy for people. They think, okay, there's a value and we should be getting a pie of it. That's simple. And taxes will be imposed the way they are. Just that right now, it's not the obligation of the two parties to ensure that the taxes are paid. A lot of it comes down to the intermediaries also. We will have to look at what would be the roles of people. Under smart contracts, people generally claim that it is without intermediaries, but that is false, because the technology platform which permits it, which in this case would be Ethereum, their blockchain, would eventually become an intermediary unto itself, and they would regulate them as well. So the taxation aspect comes down to once you recognize these as valid tender.
Absolutely. We had a similar question from Adya, who too was on the question of taxation, because taxation again is sort of state and center differ. Hopefully, the sort of GST council will sort of take care of that point that Adya had raised.
But once the states have paid the GST.
Right. So now coming to this is an interesting point, and somewhere this question is specifically asked to you. Deepa Mariam Alexander asks, and I'd come in on this before I get you on board. The question is that can you talk about the trust factor and regarding smart contracts and real world contracts? I want to add another layer to this before I pose the question to you regarding the wagering part of it. Now, the fundamental technology of not just smart contracts, but even a blockchain, is that it does away, Deepa, with the necessity of trusting the other party. Right? And the whole idea, the question that was being raised earlier, that okay, do they have enough Ether tokens in the wallet or not, etc., is the smart contract cannot be entered into in the first place if all of that is not there. Right? So, sure, what we see as traditional contracts from like a legal standpoint, okay, there's sort of huge volume of 40 odd pages. If you sort of just condense that to, let's say, a transaction, let's call it a transaction more than anything else, a contingent sort of transaction. In that end, you don't need to sort of think about, okay, is that person going to, by this period, do what he claims to do? Because if he doesn't claim it, the date is encoded in it. If you don't get the possession of your property, money comes back to the wallet, right? The date is always encoded. So that's a trust factor there. Samir, you can please come in on this, but I want to include the next layer to this, and that is on wagering aspects. Now,
Okay.
a key fundamental question, right? I don't have sort of personal experience on this, um, but a lot of people say that when there's betting on sports, when they win, the guy they're playing with doesn't end up giving them money, right? But when they lose, right, and like we say, right, the house will do everything in its power to win. I'm reminded of Robert De Niro from Casino here, that on some level, the current status, and like we discussed earlier, that the legal aspect of it, once you institutionalize it, these kind of people can be protected, right? Because there is a predatory nature to people who are also offering such bets off the institutionalized framework, right? On sporting matches or otherwise. Now, one, perhaps that can be done away with if we carry out that transaction on smart contract. At least that trust factor is no longer required, right? Perhaps on an ogre token or something. And obviously, if you want to sort of specify that the nature of transactions, not even in the legal contract sense, but let's say if you just let's say talk about a sale of goods contract of sorts, right? Perhaps that would add significantly if we get in those a couple of sort of stipulations from the hemp case, and if I've checked the goods, if I've sort of taken possession, etc. So if you would want to comment on that, right? The trust factor in the nature of smart contracts and specifically with wagering contracts.
All right, so let's start with the first question, quick,
Yes.
simple trust factor. Now, see, traditional contracts do not happen on code. They don't happen on computer. They do not happen between strangers. When you're entering into a traditional contract, even if you're strangers, to a certain extent, you're relying on each other. There's the trust deficit may or may not be there, but the assumption is that we are going on trust. Now, where there is trust deficit, there are methods such as POF, which is proof of funds, escrows, line of credits, all of that is there. Now, what a smart contract does it just assumes there's trust deficit everywhere. I want the POF right now, which is a proof of fund. The fact that the e-wallet already has the token or Ethereum, Ether, whatever you want to call it, becomes the escrow in nature. So the e-wallet is the escrow, and the fact that there has to be payment, there is almost like a line of credit that when this thing happens, when you, for instance, the sale of good, if it's an export or import, there is a bill of lading, there is a certification which is given to a third party which certifies that a product of such nature, of such quality, such quantity has been given. Once you produce it to the bank or the escrow agent, it is done. So a smart contract basically is every contract unto itself has an escrow agent, which is the blockchain itself, and the proof of funds is done initially as simple. So that is how traditional contracts also behave like smart contracts, is that they have too many intermediaries to be as secure and safe as a smart contract would. It is just one simple step. Now coming to the next aspect of wagering. Now, if you're wagering against, let's not against, if you're using a website or a house or one of these
An
platforms,
individual platform. Yeah.
using a platform. See, more than anything, I think they would like to pay because goodwill and reputation matters. Even if they don't want to pay, they won't pay. But mostly they will. That is a trust deficit which will be there. Now, if you want to deal with this scenario and say, no, no, this will happen, a house should not be allowed to take any bet which they have not covered. The greatest example being anyone, just imagine if everyone bet on Leicester and all the betting houses were like, yeah, they'll never win. We don't need to show that much proof of funds. Everything would have been lost. So you can, if you regulate it, you can ensure that you cannot take bets for over an amount that you are already secure on. Right now, there's no regulation, so it doesn't happen. If there was a regulation, it would happen. We could put that in to ensure nobody gets cheated out of it. Now, if it's down to two individuals, yes, a smart contract will protect you because, again, proof of funds, escrow is inbuilt in the very implicit
So the
nature
code,
of
the code
smart
itself.
contract. Yeah, it's already there.
Right.
But if you do a traditional contract, yes, you are relying on the other person paying you or not. But if in a traditional contract, let's say you and I are putting a bet of randomly we bet, all right, tomorrow team A is going to win. I say team B is going to win, and we bet 500 rupees each. You would be scared that whether I would give you the 500 or he or the other person would be. I would be scared if you would. We could just deposit 500 rupees to Zafar. That regardless, once the result is there, I don't need to rely on Ajay. Ajay doesn't need to rely on me. Zafar, you pay the money and we're done. Zafar here becomes a smart contract. Zafar here is the escrow.
But you still have to trust that you won't run away with it.
Yeah,
That is
exactly.
the yeah.
Exactly.
So right now, a smart so a code will not run away with it. An intermediate. So as long as there's human intervention, it is possible. So it
Yeah,
is
and
safer.
just to add there, of course, because commenting on the nature of smart contracts which are built on blockchain technology is that when you're saying that I'm not going to run away with it, nobody can steal me either,
Yeah.
because it's not on one person's, it's not on one server, it's not one, it's a decentralized ledger. It's spread across 100,000 different nodes in a blockchain. So
Yeah.
someone can't just hack one thing and take both your money and run away.
This is assuming everyone knows what nodes and hashing and DAPs are, DApps and all of that.
Let's, I mean, a decentralized
See,
ledger,
I have
Yeah.
it's
so
pieces of information across many different
Yeah.
nodes or server systems, computers, which make up a single ledger spread out.
To put it simply, basically the fact that Ajay and I entered into a wager is known to everyone, so neither of us can go back on it now.
I think that's pretty apt. We've taken a significant number of questions, though we still have a lot more questions coming in. But
Let's do one more. Let's do one more. Come on.
I was actually going to call it close, but okay. Zafar is okay. Let's get this question from Uday Srivastav. Let's get this. How do investors in the stock market in gaming companies like Delta Corporation? Yes. So Zafar asked for a question, as it happens to be the case. This was
You were, this is all you, man.
So I won't
You
read
asked
out.
for it. You asked for it.
Okay. How do investors in the stock market and gaming companies like Delta Corporation, a listed stock, view the development of regulation in the gaming sector? Would it be open to more states in the future? Further, Adda 52, which is owned by Gaussian Networks, has also been acquired by Delta. Can we expect that more states would allow casinos to open, and in what frame?
Uday, that's a good question, and I think that if we look at, this is a bit of a legal question as well as, in essence, a political question, because the legislative will is driven to a great extent by political will, which is often driven by a perceived political morality. Now, why do there are some states in India that will look at Goa as being quite hedonistic, or quite maybe not up to the moral values which that particular state or those particular people might hold, because Goa allows gambling. Sikkim has casinos as well. It's not looked at as maybe as much as Goa, but Sikkim has casinos as well, where by executive action the local populace of Sikkim is not allowed to go, is not allowed to attend. So there's an ingrained recognition of gambling being a social evil. So time frame, if only I could predict what is the time frame for India becoming more enlightened and liberalized. The answer may have been different 10 years ago, and it may be different today. So I can't comment on where India will be in 5 years. To come to the first part of your question, however, how do investors in stock market look at this thing? I think that if you look at the reports in the trends in the gaming industry and the boom in the gaming industry in India, online as well as offline, if you look at the reports by KPMG, if you look at the reports by Deloitte, they have recognized that this is an extremely vibrant and fast-growing industry in India. They've recognized that gaming is a fast-growing industry, and sooner or later, now when a lot of people are playing games, it's gonna be monetized. It's that is inevitable. Now, to what extent people have to work around the law, to what extent lobbies push for new law, and to what extent one leads the other. That's something that we will see when we see, as we've come to the conclusion. The law is what the law is, but the law sooner or later does have to catch up with commerce. It can't ignore it because everyone has to follow the money, and basically, if you have states that refuse to regulate and recognize the potential of this industry, then they will be left behind while other states in India make a lot of money on their licenses and on the taxation.
Okay. I think that's absolutely pertinent. Samir, any final comments on this question by Uday?
See, the question as the stock market itself is speculative, so I will not say anything. The fact that whether it happens or not is another thing. The fact that we regard the the stock market in itself is a game of skill. Let's be honest. Um,
Nagaland
now,
specifically recognizes it as well.
yeah, and it's more of a game of chance than poker, as let's
Oh,
be honest.
certainly. I would say certainly. There are certainly
Um,
far more factors that you cannot see or control.
Quay Delta, if you're invested in it, I can't speak on the company. It's not a legal question. But yeah, see, eventually going on pure numbers and how the industry is going, it makes sense to open it. We should, now I'm talking beyond the law, we should promote this because most of our companies, as we know, have foreign investments. Indian companies usually are not allowed to do it. There are modes through which one can put money into another company in another jurisdiction and it just comes around. But I think we should promote our own sectors. We should regulate it. This is an industry which, see, there was a time where all these things were done in a very shady manner. Nothing was on. Nothing was on electronic record. There was hardly any record of it. There was enough space to fudging it up. I think with new regulations and new technologies, we should wake up to this change and we should bring in a framework wherein we protect the people and we protect the industry. And I only see good things coming from incorporating it into the clean economy. Why should this be outside?
Certainly. I think thank you so much, Uday, for this pertinent, very important question. And many thanks to both our panelists for the evening. Zafar, Samir, thank you so much for joining us.
Thank you for having
And
me.
I hope neither of you is placing a wager on us ending within an hour. Thank you so much for staying, at least I think
It wouldn't have been a
80%.
smart bet. It wouldn't have been a smart bet.
Yeah, on smart contract or otherwise. Yeah. Thank you so much for joining us. And thank you so much to our audience, our viewership as well, for sort of joining us and for sticking with us for much longer than at least either of us anticipated. I think it was a great discussion. And we hope that we can get both of you on board for some of our discussions in the future as well. Most of whom
Absolutely. I
focus
think
on
I think I'm happy to speak for Samir as well and say that we'd be happy to come on board. And it's been a good discussion. And I certainly think, as I said when I started talking, is that there are plenty of people in our own sector who don't necessarily understand the nitty-gritties of these sort of niche areas of law. And so it's great to discuss it openly with so many people.
Certainly. So we continue our conversations on law, economics, and technology. And I've been told once again by my team, because I don't say this too often, but please share, like, subscribe, press the bell icon. And I've been doing it at least for the last few sessions now. Right. Thank you so much, everyone, for tuning in. Enjoy the match tonight. And thank you so much, Zafar and Samir, once again. It's been a pleasure.
Thank you.
Good night.
Thank you, everyone.
Thanks.
Stay safe. Good night.